Me? Hello, my name is Lai-King Hum, and I'm an employment lawyer. My profile would be in your material, so you can feel free to look at it, but just very quickly, I've been practicing as a lawyer for over 20 years, mainly with big firms in Montreal and Toronto, until I started my own firm. Wow, it's been about 8 years now. I'm in my 8th year. So I have a small team. It's a boutique employment law firm. We also do some other things, but our main focus is employment law. I'm called in both Quebec and Ontario, and work with many employers with issues across Canada. My presentation is generally about non-unionized workplaces. We do some labor relations work, but this presentation is focused on the non-unionized workplace. I want to speak to you about changes in employment law since we began this COVID-19 journey in mid-March 2020, and the rights and obligations that arise from changes in the law since we began this journey. Many of the changes were intended to tap into the resilience of businesses to meet challenges of the economic consequences of the lockdown, so that businesses can stay open and jobs are still there. But there are still hard decisions to be made as the state of emergency in Ontario has come to an end. I am trying to click through my video. So I'm going to speak to you about how this journey has been marked by some suffering through the COVID blues. And for those amongst us who are more fortunate to continue business almost as usual, the scourge of Zoom fatigue. I love being in presentations where I get to meet people. I'm meeting people, but this is a very different platform. And as many of us get back to work, we can feel this is at least not forever, it's just for now. However, my experience dealing with businesses has been that there are still hard decisions to be made, and knowing your rights and obligations is crucial to a successful transition to what the new normal will be. Let's take a few minutes to appreciate the journey so far. It's been a complicated journey since the COVID-19 pandemic began. My team has regularly monitored the almost weekly changes to convey to our clients. So there has been a myriad of federal and provincial measures responding to potential economic devastation of the lockdown, along with unprecedented loss of jobs and talk of recession. Let's look back a little bit so we can move forward. So on March 19, there was a declaration of a state of emergency and a lockdown of all non-essential businesses. With the lockdown, employment lawyers, including myself, expected that there would be a flood of constructive dismissal claims as so many people were put on temporary layoff. However, at that time, it was surprising, and employees that consulted me really felt that they would prefer that this was an extraordinary time. It was a government mandated lockdown, and they preferred to be on layoff with the potential of going back to work rather than immediately claiming that they had already been constructively dismissed. So interesting situation. Then, as the temporary layoff period started, the impending expiry of the temporary layoff period of 13 weeks was about to come up in the middle of June. The government on June 1 declared the infectious disease emergency leave. Now this leave changed the ESA, made amendments to the ESA such that it deemed all employees on layoff to be on emergency leave. And this meant that any time during the COVID-19 period would not count towards the running of the temporary layoff period, and everyone was on job-protected unpaid leave. And that leave would remain in place until 6 weeks after the end of the declared emergency. That emergency, a state of emergency, was lifted July 24 with Bill 195. And employers now have the tough decisions to make as of September 4. So September 4 marks the end of the COVID-19 period. And between that, there's also the mandatory, if you're in Toronto, the mandatory mask laws. All of these things were a complicated journey. And I know that myself and my team were constantly monitoring the press releases, the different relief that was available to employees, the different measures that were taken to try to alleviate the devastation, the economic devastation that could happen to businesses during this whole period. So, what were the top things that I saw during this time? So some of the questions arise as a result of all the workers that were put on temporary layoff as a result of the lockdown. And the temporary layoffs, you have to remember that the ESA doesn't actually give employers the right to implement layoffs. It merely provides the rules to do so. And what happened when the lockdown first went in was that many people were temporarily laid off. Were employers entitled to do so? In some cases, if the contracts provided, then yes, they were entitled to do so. In my experience, most employment contracts do not contain temporary layoff provisions. And there was the risk of constructive dismissal claims. As I stated earlier, many employees opted not to invoke constructive dismissal, believing that at that time that the lockdown would not be as long as it ended up being, and that they preferred to have a job to go back to rather than claiming constructive dismissal. And so there's a difference between temporary layoffs that are contractual temporary layoffs, where you have an employee that, or you have contracts for your employees that contain provisions allowing you to temporarily lay off when the business needs it, and non-contractual layoffs where you don't have a contractual right to do so. In those instances where you've laid off employees, or if you're an employee that has been laid off and your contract does not contain a temporary layoff provision, then there is, you do have the right to claim a constructive dismissal under the common law. If there is no contractual right, then it would be considered a common law constructive dismissal, and the employee would be entitled to seek damages for wrongful dismissal. As this, the state of emergency was lifted July 24, and 6 weeks after the lifting of the state of emergency, the emergency leave is expires. So as of September 4, employers have to call back employees, return them to work, or there is they have to decide to terminate, call them back to work, or possibly again temporarily lay off workers. If the employer decides to temporarily lay off workers and there's no contractual right to do so, I suspect at this time, unlike the earlier layoffs, I suspect at this time that more employees will not be as patient and may invoke constructive dismissal claims. So this is something that employers need to be aware of. Another issue that I think has arisen persistently over this COVID-19 period is the right to demand workers return to work. I found that as non-essential businesses were phased back, I had many inquiries about whether, look, can I force my employee to return to work? Many were saying that people were scared to return. They didn't want to do the long commute into work because of physical distancing concerns. So can employers demand employees return to work? Absolutely. However, it's subject to a duty to accommodate for legitimate ESA type leaves. So maybe compassionate care leave, family obligations, or for human rights issues. And so long as you have the appropriate safety protocols in place in the workplace. I urge people to, or I tell people to look at Public Health Ontario, and it provides safety protocols for different industries on their website. And I find it's a very useful place to go if you're not sure what safety protocols you need to have in your workplace. So employers can and do have the right to expect workers to return to work to do the work that they're hired to do. Or they can fire for cause, for abandoning their work. I have been telling my clients, however, that while you have this right to do so, I caution people to be flexible. You know, we're still in a pandemic. There isn't a vaccine. There are still social distancing measures in place. And so I've asked my clients to thoroughly review the situation before immediately firing someone who refuses to return to work. Look into it first and then consider terminations. The other issue that has come up, and it has come up with clients that are facing economic devastation, possible closing down of the business, is whether or not frustration of contract can be claimed. So as the looming deadline of September 4 comes and employers have to make hard decisions about whether they can return people to work, or if they cannot return people to work and they are fairly certain that their business will either close or significantly be reduced, then is there some way to alleviate the impact of deemed terminations? Frustration of contract, therefore, has come up, and frustration of contract is a possible defense to claims of termination pay or severance pay arising from the loss of employment. How frustration of contract would work is the employer could claim that the contract on their part has been impossible to perform because of measures that were in place. Now, during the pandemic and during the lockdown, it is true that many non-essential businesses could not open. So it's true that was impossible for them to open. However, it was a temporary measure, and we are now in a phase. We're now pretty much back to work. Most businesses can return to work, and it will be difficult for businesses to claim frustration of contract unless they are really impossible to open for business. I can think of scenarios where some businesses might be able to assert this novel claim. I should mention that such a defense or has not been decided by Canadian courts. I have the intention of searching in other jurisdictions to see if such a claim such a defense has been successful. But I can think of concert venues, movie theaters, nightclubs, all venues that require 50 or more in one venue to effectively open, and where physical distancing, even with just 50 in place, may not be possible. So when you're looking at frustration of contract on the employee side, and I'm sure people in HR will be familiar with this, if an employee cannot return to work because of medical issues or other circumstances where it makes it impossible for them to work, then the employer can claim frustration of contract because the employee cannot return to work. In those circumstances, the ESA does require that minimum termination notice or pay in lieu of notice plus severance pay would be payable to the employee. But the ESA does not deal with issues of frustration of contract that an employer might be able to claim. That would be a common law frustration of contract. And it has, as I said, it's not been tested in courts. And the test would be that the contract is impossible to perform due to a fortuitous and unforeseeable event. So can we say that the COVID-19 is such a fortuitous and unforeseeable event? So that would be one part of it. And the second part of it would be, well, is the contract, is the employment relationship really impossible for the employer to perform? I'm very interested to see whether we will be seeing such cases in court. Yes, and the employer has the burden of proving both that it's impossible to perform the contract to keep the relationship going, and that it is a due to a fortuitous or unforeseeable event. Interestingly, because I'm called to the bar in Quebec, I keep track of what's happening there. And Quebec's commission, the equivalent of the Employment Standards branch of the Ministry of Labor here, they have said that an employer who has laid off employees during the pandemic could claim that they are in a force majeure circumstance. So similar to a frustration of contract argument, but under the concepts of civil law in Quebec. So let us now go to temporary layoff. As I said, can we expect a tsunami of terminations or constructive dismissal claims shortly after September 4? Certainly. We will see terminations. So we will have some people recalled back to work, and in other circumstances, we will see actual terminations of employment as employers strategize and determine how much of a workforce they can continue and how much business they can continue to operate. For others, where they are unable to accurately determine at that time, they might consider temporary layoffs. As we discussed earlier, the emergency leave put everyone on deemed emergency leave. The infectious disease emergency leave amendments to the ESA put everyone on emergency leave. So the clock for temporary layoff starts again on September 4. If it is a non-contractual temporary layoff, again, as I mentioned earlier, you may be faced with constructive dismissal claims. If it is a contractual layoff, then you follow the temporary layoff rules. If it is a non-contractual layoff and the employee doesn't complain, you would still follow the temporary layoff rules. And it's important to understand these rules. So if you are laying off someone and you're not providing any benefits, then you've got 13 weeks in any 20-week period that you can lay a person off and not have the deemed termination provisions triggered. Otherwise, in some circumstances, such as when you're providing benefits or you're providing some form of substantial payments to the employee, you're continuing supplementary unemployment benefits, then you can lay someone off for 35 weeks in any 52-week period. That could take some employees put some employees for a significant amount of time after September 4, you can lay them off. Now, earlier, the layoffs that occurred in March, I found that many employees simply accepted that they would be laid off and would eventually be recalled back to work. I think this time you're not going to see the same type of reaction. I think we've already experienced layoff conditions since March, and I think the same sort of patience may not be sustained. So I suspect that many employers will have to make very hard decisions, and if not to actually terminate, that they will be faced with constructive dismissal claims. And again, if you go past the 13 weeks or the 35 weeks in some circumstances, then you will have been deemed to have terminated those employees. Now, this is an interesting development in the law that occurred in the middle of June, just recently. It's a groundbreaking decision, and this will significantly impact businesses as they start to terminate or as they face constructive dismissal claims. I have read some commentaries saying that the impact of this decision, the Waxdale versus Swigan decision of the Court of Appeal, will render close to 90% of employment contracts to be ineffective. I don't know. This is what I read. I do know from my experience dealing with various employers that many contracts will have their termination clauses be unenforceable. So let me speak to you a little bit about this, but I don't want to go in too much detail because I only really have half an hour. So it is a groundbreaking decision. Basically, many employers won't be able to rely on their termination clauses. Most termination clauses, as you know, will contain both a termination with cause provision as well as a termination without cause provision. And until this decision, if you relied on a termination without cause provision, then the courts would look at only that provision to see if it was enforceable. With the advent of this decision, the entire termination provisions have to be looked at altogether. So in this case, someone was terminated without cause, and the employee sued for wrongful dismissal because they felt that they are entitled to common law reasonable notice. The termination clause in this case was ESA plus 1 week. To making the argument that they are entitled to reasonable notice of termination, they asserted that the termination with cause provision was unenforceable because it breached the ESA. And the Court of Appeal reversed the summary judgment motion judge who did not agree with the plaintiff, with the employee. The Court of Appeal agreed that if the termination with cause breaches the ESA, then the entire termination clause will fail, which rendered the termination without cause also to be unenforceable. And there was also a severability clause, and I'm sure many of you who are familiar with termination with employment contracts will be familiar with severability clauses, where it states if one clause is unenforceable, then it should not affect any of the other clauses in the contract. Well, the Court of Appeal disagreed and felt that the entire termination clause has to be read as a whole. If the termination for cause fails, then the entire clause fails. Why I bring this up in the context of this discussion as I go through the whole journey of the COVID-19 and changes in employment law is as we move towards September 4, as we move towards the end of the emergency leave, and employers have to make hard decisions about whether or not to call employees back to work if they can, and if not, whether they terminate or continue to lay off, is that this decision may impact the financial risk assessments that employers make as they consider how to implement the terminations and what liability they may have. I strongly urge people to have their contracts reviewed and to do so prior to making decisions about terminations, including starting temporary layoffs again, where your contracts do not have temporary layoff provisions. I'm happy to talk about this further with anyone who wishes to. So I notice that my time is coming up. I have about 4 minutes. I do want to touch a little bit on employer rights, human rights, and health and safety issues. I pointed you earlier to Public Health Ontario. It's a really good website to provide you with health and safety protocols as we continue in this pandemic world. So employers have obligations to ensure that workplaces are free from, well, we can deal with Human Rights Code, free from discrimination or harassment that breaches the Human Rights Code. That would include anything that is related to COVID-19. So you may have employees who have health issues, who may also have family obligations related to people with health issues. You have to ensure that you are accommodating for that. This does not really change your normal obligations, pre-COVID obligations under the Human Rights Code, but it's an extra layer that you have to pay attention to. And the same thing with the workplace, being healthy and safe and free from harassment and compliance with the Occupational Health and Safety Act. The responsibility lies with employers to ensure that the workplace is safe. This includes the health and safety protocols related to COVID-19, and look to Public Health Ontario to see what those health and safety protocols are so that you can comply with your obligations. Employees will be able to claim that they are not obliged to return to a workplace or to work in a workplace that does not comply with health and safety measures. I have left some room for questions, and I see some now. Oops, I don't see it up. Okay, do you? Yes, there it is. What if a business that still can't open? Yes, so even with businesses that cannot still open, I sympathize with those businesses. I'm dealing with some, and the laws as they exist will still require that decisions be made as of September 4. So as we enter into the state of emergency, businesses will have to make hard decisions. You will be, if you have employees that are on layoff right now, you have to recall them to work, terminate them, or put them on temporary leave. The temporary leave provisions start running again as of September 4. Unfortunately, I don't have much more to say about that, except that you may fall into the category of businesses that might claim frustration of contract. For Frank Zhang's question, if the employee had been laid off for 13 weeks in any 20-week period before September 4, no. So the period starts again, as I may not have been clear, but the period starts again as of September 4. The time before September 4, the employee was deemed to be on emergency leave, not on temporary layoff. I've come to the end of my session. You have my contact information. I'm happy to answer any more questions. And thank you for attending my session.